Today we're talking about contingency fee. This is the information that is provided by the Law Society of Ontario to any clients who are looking at signing up for a contingency fee retainer with a lawyer. I'm going to go through it today. I'm Natalie Gerry from Gerry Law. I help injured people get the compensation that they deserve for their injury. Let's get into it today. We're going through this PDF provided by the Law Society of Ontario, but getting into what a contingency fee is, why you need to know this, what your rights are, and various other things. The link to the PDF is found below, so please check out the PDF itself, but this video gives a brief overview of what is contained in that PDF. Let's get into it. First of all, what is a contingency fee anyway? If you have a legal matter where you might be entitled to compensation money at the end of your legal matter, most of these matters can be taken on by a lawyer if they agree in the form of a contingency retainer. This means that once you are awarded the money at the end of the file, the lawyer takes a percentage of that money instead of taking legal fees as you go, probably invoicing you on a monthly basis for the lawyer's hourly rate, which can range but can add up quickly and can be expensive. So the contingency fee retainer means that you don't pay those legal fees until the end of your matter. Once you are getting your money, then your lawyer is also paid at the same time. What's important to know about this is that it's a bit less risky for you because you don't have to pay legal fees for the most part if the lawyer does not win your case and if you do not recover money for your matter. But you might be on the hook for other types of fees, and I will get into those. The guide that's linked below has to be provided by any contingency lawyer in Ontario to a potential client before they enter into a retainer agreement. Before you sign anything, if you're in Ontario, your lawyer has to give you a copy of the document linked below where you are able to understand your rights and ask any questions about the retainer. It's important that you read through the information before you sign anything. Now I'm going to get into some of the commonly asked questions about contingency fee arrangement. One question that is really common for clients is, can any legal matter, any type of legal matter be taken on a contingency basis? The answer to that is no, not every matter can be taken on contingency. As mentioned, if you aren't going to be entitled to money at the end of your legal matter, then that one cannot be taken on contingency. But also lawyers are prohibited from taking criminal matters or family matters on a contingency basis. It's just not allowed. Now I'm going to get into some of the advantages and disadvantages of a contingency fee agreement. As I mentioned, the advantage to the client with the contingency fee is that you don't pay the legal fees on a monthly basis and you don't pay the lawyer's hourly rate necessarily. So this can be a benefit to the client. The other thing is, if you do lose your case, then you wouldn't be paying any legal fees to your lawyer. But there are other fees that you might be paying. And the disadvantage of the contingency fee retainer agreement is that if your matter is fairly straightforward and it's easily resolved, then you might end up paying actually more than what you would be paying hourly to the lawyer at the end of the file, because the percentage that they take of your money might end up being a larger amount of money than had you just paid the lawyer for their time straight out. That's something to keep in mind, that if you think your matter is fairly straightforward, you need to really think about if you want to pay on an hourly basis and just pay that lawyer as you go, so that at the end of your file, you're not paying such a high amount. The other thing that you need to give some consideration to before you sign the agreement is what would happen if your lawyer were to end the agreement. If the lawyer has a reason to end the contingency fee agreement, then usually the retainer does contain a clause that says that then you are paying their hourly rate. So it would be listed in the contingency fee agreement how much their hourly rate is, and the lawyer would give you a bill for that amount. Then you could go and see if another lawyer would take your file, but eventually your first lawyer's fee would have to be paid out of whatever settlement you receive. It's also important to remember that you may be on the hook for other types of fees. So there's not just legal fees in your matter, but there are other types of fees. You may be wondering, what are these other fees that might not be covered by my retainer agreement? That's an excellent question. These fees are called disbursements for the most part, and these are fees that your lawyer has to pay out of pocket to advance your matter. These are things like filing fees. So to do your statement of claim and then file it with the court, there is a fee there. There are fees associated with discovery, and that's where you're examined for discovery. And the fee is associated with the court reporter and then also ordering the transcripts. These are where there are actual costs to your lawyer for advancing your matter. And your retainer agreement will spell out how those will be paid, whether you have to pay some amount of money up front or if you pay as you go. The other types of fees, disbursements, the one that can be very large is that of an expert report. If you need an expert report as evidence in your matter, those expert reports can cost several thousands of dollars depending what type of expert it is. So it's important to be aware of that. Your lawyer likely will make you aware upfront of those costs, and especially before they're incurred, but oftentimes they are very important for your case, and you do need those expert reports, and you need to be filing those documents. You need to be getting medical reports and medical records from your providers in order to provide evidence for your case. So it's important that you're aware that those amounts for disbursements are in addition to the contingency fee, and the retainer will spell out how they are paid, whether it's upfront or as you go or at the end. The other expense that you need to be aware of that will not be covered in your contingency fee agreement is costs. So costs are legal fees for the other party, but also for your lawyer's costs. Your lawyer will be claiming for costs in your lawsuit to cover part of their legal fees. That's something that you can recover from the defendant, but if you were to push your case forward and you lose, or you want to discontinue, then sometimes costs have to be paid to the defendant. This is something your lawyer will definitely talk with you about the strength of your case and any issues. And if you are going to trial, then you will definitely be talking about the potential costs that might be payable if you lose your trial. So the costs of the defendant are payable by the client if they lose their case. So at the end of the trial, if it is a loss, then the defendant will be looking to have their costs paid, and the plaintiff is responsible for these costs, but your lawyer will keep you in the loop and will let you know about the risks of this. It is their job to keep you updated on those risks. You may be wondering about this deductible that is sometimes discussed. If you were in a motor vehicle accident, you need to be aware that there is a deductible that would apply to your legal matters if you are entitled to general damages, which is a little bit complicated issue because you have to hit a threshold of general damages and you have to meet a threshold in order to claim for general damages. But if you don't meet that threshold, then there is a deductible that is applied to reduce the amount of damages, the amount of money that you would receive. Your lawyer will talk with you about the specifics of what that deductible means, and I can be contacted for more specific legal advice about your situation because every legal matter is so different than not. This video can't cover everything, so you really need to speak with me directly about your matter, and I can be contacted at the information below to discuss your particular legal matter. Moving along, You might be wondering how legal professionals set contingency fees. So the way that they are set really depends on a lot of different factors. One thing to be aware of though is that lawyers do have the obligation to publish the maximum contingency fee that they would take, and that is on their website. If you look on a personal injury lawyer's website, they will have their maximum fee published on the website. It's important that you have a look at that. The way that legal fees though are set, so the contingency fee, it can be higher in some situations, and it depends on the level of risk on your file. It depends how much time the lawyer thinks it will take. It depends on various factors, and your lawyer will discuss that with you when you're talking about the amount of the contingency fee. But it really depends on the difficulty, the amount of risk, and various factors. Sometimes there is a fluctuating contingency fee, and you will be able to compare them if you speak with various lawyers, but then it's important that you assess the contingency fees before you sign the retainer agreement. You should be aware that the legislation does set the maximum that a lawyer can charge for a contingency fee, and that fee cannot be larger than what you receive as the injured person for compensation. Just to note though, that includes costs, but it does not include disbursements or HST. So disbursements, as I mentioned, can be a large fee, and that's just for actually advancing your case, depending on how many experts there are. The fee that the lawyer takes for the contingency does not include disbursements. Those are on top. So the amount that the lawyer receives, it cannot exceed what you receive, but that is before the disbursements are calculated. It's important to know that in every case, what the lawyer accepts as the contingency fee has to be fair and reasonable, and there will be a way set out in the retainer agreement so that you can challenge it if you don't agree with the fee being charged. Now I'm going to talk about the different ways that a contingency fee can be set up. There are different ways, and this just depends on your agreement with your lawyers. You can just have a flat contingency fee where no matter when your file settles or if it goes to trial, you are charged the same percentage. You can have a graduated contingency fee where if you settle before a certain date. There is a third way that you can arrange your contingency fee, and so this involves paying an amount hourly for the lawyer's hourly rate, and usually is a lower amount than they would normally charge. And then you could also pay a contingency fee at the end, and that would normally be a lower percentage than they would charge if you were not paying throughout the matter. These are different ways that you could bring up with the lawyer if you're interested in structuring the contingency fee differently. You might be wondering, how can I compare what different lawyers are offering in terms of a contingency fee? As I mentioned, lawyers are obligated to post the maximum contingency percentage that they will take from your matter on their website. So if you have a look at the lawyer's website, you should be able to find that contingency fee. The other thing is, normally personal injury lawyers do offer a free consultation to discuss your matter, and this would also include talking about the contingency fee retainer. Once you've had the opportunity to talk with the lawyer, see if it's a good fit, then you could talk about what percentage they're taking, and you could compare different lawyers by speaking with them and having a free consultation, seeing which one is the best fit and seeing which one's fee you prefer. You have the right to know about your lawyer's educational experience and their background in your type of case. So you can feel free to ask them that, and it might be on their website, but also you can ask in the consultation with them. You can ask in your free consultation, and you should ask what kind of experience they have with a case similar to yours. Another question that you might have is, who will make decisions in your case? Once you hire a lawyer, you might feel a little bit like they're taking over your matter and they're making a lot of decisions about how to move forward. But ultimately, you as the client are always in charge of your matter, and you are always the one in the driver's seat. Your lawyer is there to give you guidance and tell you what your options are, and to give you recommendations based on their experience and knowledge of the law. But ultimately, the decision rests with you as the client, how you want to go about your legal matter. Your lawyer is there really to guide you through the process, provide you with options, but you are ultimately in control. You might also be wondering whether you can end the contingency fee agreement at any time or at all. Yes, you as the client, you can end the contingency fee agreement at any time that you want. You are free to go and get a new lawyer if you want. What you need to be aware of is what I mentioned before. Usually the lawyer will be looking for their hourly rate worked on your file, and they will be protecting their account. So with your new lawyer that you go to, they will be looking to have that account paid. The lawyer cannot just end the contingency fee agreement at any time. They have to have specific reasons. So those reasons are spelled out in their ethical obligations, and those include things like if you as the client tell them to do something that goes against their legal obligations or their ethics, if you lie to them, if you refuse to accept their advice on a critical point, if you are persistently unreasonable, if you are hard to get a hold of to get instructions and they feel like they cannot properly work on your matter, if you do not pay your bills on time, then they can end the retainer. Or if the lawyer feels that acting for you is placing them in a conflict of interest, then they are able to withdraw from your matter. You should also be aware that no matter who ends the retainer agreement, you will likely still be on the hook for the lawyer's fees plus HST, and all of that will be spelled out in the retainer agreement. It's important to ask any questions that you have on that issue ahead of signing the retainer agreement. Moving on, if you win or settle your case, you might be wondering how you get your money. So the way that this happens is usually the insurance company or the defendant, they will pay the settlement money or the judgment to your lawyer, and your lawyer keeps it in what's called a trust account, which means it's not the lawyer's money, it's your money being held in trust. But then the lawyer is able to pay the contingency fee out of the trust money and will then give the rest of the money to you, usually by bank draft or check. You should also be aware that the lawyer has to provide you with a detailed statement of account. So this statement of account will have many details on it to look at. The amount of the settlement or award will be listed, the amount of the contingency fee, the amount of all outstanding disbursements will be listed, the amount of any other deductions that your lawyer is taking will all be spelled out, and there will also be a way listed on the account so that if you don't agree that it is fair and reasonable, then you can challenge the account, and that's always your right to challenge the account. In some cases, if a party is represented by a litigation guardian because they are either a minor under 18 years old or they are incapacitated due to an injury, then the judgment has to be approved by the court. So a motion has to be brought to approve the settlement, and usually the money will be paid into court until such time as it's appropriate to have it released. That's a detail that should also be discussed with your lawyer. In looking at some examples of how a contingency fee works, there are examples in the PDF linked below. And if you have any questions about these examples, please feel free to reach out to me and I would be happy to discuss your legal matter and any questions that you have about the contingency fee agreement. Please reach out to me in the contact information below. I'm Natalie Gerry. I look forward to speaking with you.